Should you file your USPTO trademark as use in commerce or intent to use? Imagine you have a new product idea or a fresh brand name. Now, you're ready to protect it with a trademark. But do you know the best way to start the registration process? That's what we're here to figure out. When you apply for a trademark with the United States Patent and Trademark Office, you have two main options. One is for trademarks already in use, and the other is for those you plan to use soon. Understanding the difference can save you time and help you secure your rights early. If you are already selling your goods or offering your services under the mark across state lines or in ways regulated by Congress, then you should file based on use in commerce. This means you are actively using the mark in the marketplace. To do this, you need to submit a specimen showing the mark in actual use, like product labels, packaging, or advertisements. This allows your application to move faster because the USPTO can verify your use right away. Once approved, your trademark registration is almost immediate. On the other hand, if you have a great idea but haven't started selling or offering your services yet, then intent to use is the way to go. This filing shows you have a genuine plan to use the mark soon. It gives you an earlier filing date than someone who files later, helping you establish priority. After the USPTO approves your application, you get a notice of allowance. Then, you must submit proof of actual use by filing a statement of use. This step confirms you are now using the mark in commerce. You have a limited time to do this, usually 6 months, but extensions are available if needed. Choosing between these options depends on your current situation. If your mark is already in use, filing based on use in commerce makes sense because it can lead to faster registration. If you are still developing your product or testing the market, intent to use offers protection early on, even before you start selling. Just remember, intent to use applications requiring careful planning. You need to document your genuine intent to use the mark and submit proof of use on time to avoid losing your rights. Both options establish a priority date that can be very important if someone else tries to register a similar mark later. For businesses that already operate under the mark, use in commerce is usually the straightforward choice. For new brands or products, intent to use helps secure your spot in the trademark queue before you even start selling. In summary, if you have already begun selling or offering your services under the mark, go ahead and file based on use in commerce. If you are still working on your product or brand and plan to use the mark soon, filing intent to use is your best bet. It protects your rights early and keeps your registration process moving forward.